Good morning. I hope everyone had a great weekend. Maybe got a little bit of Oktoberfest in while we were at it, a little extra chicken dancing, although the weather was not necessarily conducive to all that. So today is Monday, September 23rd. We have 4 cases on the docket. 3 are going to be arguing this morning. One of the cases has submitted on the briefs. I'm going to be calling out all 4 cases. Those that are represented, if the attorneys can please identify themselves and their readiness to proceed. The first case I have is case C230559, State of Ohio versus Riley.
Judge Stephanie Kessler for Demetrius Brady, and I'm ready to proceed.
Good morning.
Good morning, Your Honors. Keith Sutter for the state, ready to proceed.
Good morning. Then we have case number C240230, State of Ohio versus Brown.
Norbert Wessels on behalf of the state, we're ready to proceed.
Good morning, Your Honor. Connor Riley on behalf of Kelly and Brown, ready to proceed.
Good morning. The next case it has submitted on the briefs, case numbers C230498, C240157, Ohio versus Langston Ward. And the last case we have that we'll be arguing is cases number C210468, C220343, C230557, Burkika, help me out. Burchika.
Yeah, I
Bur-
pronounce it
Burchika versus Ludi, right?
Yes.
All right,
I'm here for Ms. Burchika, and we are ready to proceed.
thank you. And,
Good morning, John Alfion on behalf of Natalie Lee.
okay, thank you. So we're going to start off with,
Your Honor, this
oh,
is
that's,
Rice on behalf of the involuntary parties, the Tate attorneys, ready to proceed.
can you repeat your name for me, please?
My name?
Yes,
Michael Rice.
thank you so much. All righty. All right, thank you. All right, so we're going to start with State of Ohio versus Demetrius Riley.
Good morning.
Good morning.
I'd like to reserve 3 minutes.
3 minutes. Okay, whenever you're ready, you can begin.
Thank you. I'd like to start this morning with a discussion of the concurrence in the Smith case. The Smith case is one of the cases I cited to regarding the excited utterance option, or issue rather. In Smith, that was a case where the Ohio Supreme Court majority decided the triggering event for the mother's excitement was not her boyfriend walking into the room with the deceased baby, but instead the majority decided the triggering event was the death. The concurrence decided differently. The concurrence concluded that the triggering event was actually when the boyfriend walked into the room with the baby. The reason I bring that up is it's significant that the majority had considered that. They considered which event was the triggering event for the excitement and concluded that it was in fact not the man walking in with the baby. And that matters when we look at the latter case, which is Jones. Because in Jones, the Supreme Court decides actually the statement, the husband's statement to the wife that he had murdered somebody, was the triggering event. And so I think one of the important things in this case on that issue is which one. Because to me, when I first read these cases,
Because really it comes down to the triggering event and then the proximity in time of that event to the alleged excited utterance,
I agree.
right?
I
So
agree.
it's what that is, it is the, kind of creates a dependency on determining also the time
Right.
that lapsed.
I agree. And so that's when we're looking at, well, how do we decide what's the triggering event in this case? Because the Ohio Supreme Court in Jones did not actually overrule Smith, they could have. They could have agreed with the concurrence. They could have overruled it. They chose not to.
Counsel, do we have any guidance about how we are to determine what the triggering event is, other than these 2 different outcomes? Does the court ever explicitly tell us some kind of test or criteria?
I did not see anything from my reading of these cases that there is any sort of test for how to determine it. The only thing that I think drives my analysis was the discussion in Jones, where they distinguished Jones from Smith on the basis of the facts were a confession. So I think that's the only guidance I've seen in these cases to use to distinguish the two.
How do we ground this to the essential purpose of this hearsay exception being the idea that the statement is true? This is a proxy for the truth, right?
I think that's one of the issues that I struggle with as well, and I think it comes back to why a confession is different than a different type of statement, right? So in our case on the facts, the mother wasn't there when it happened. She gets told about it, and then she's telling what she's told. So you have a double hearsay exception. She's not around.
Well, but I think like this tumbles into my concern about, like, let's assume that you're right, the harmless error aspect, because this isn't like the prototypical excited utterance, like, I saw him do it. It's, I heard this, I learned this, and I believe my daughter who is the victim. I mean, it's not unusual to have a parent believe a child. So since there is other evidence of the assault occurring, like, how is this ultimately prejudicial to your client?
I think it's the mother vouching for her child that's prejudicial. Like, I hear what you're saying. We can assume a parent believes their child, but that's not necessarily always true. I think if the mother had been available for cross-examination, perhaps there would have been some facts to get out. Maybe their relationship wasn't good. Maybe something else was driving her to believe her daughter. Maybe there was some other interest going on. We don't know because the mother hadn't testified. And I think when we look at the fact that they acquitted Mr. Raley on one of the counts, and the only evidence on that count was the testimony of LT, to me that lends to the conclusion that the jury is not finding LT to be wholly credible. So if we are looking at the evidence and we have her testimony, reason to believe the jury has not found her to be 100% credible, now on the counts of conviction that the mother spoke about, now we have to think, well, did the mother's vouching for the credibility of her daughter sway the jury as to those other counts? And I think for the harmless error analysis, that's where I think the DNA evidence really comes into play, because the other evidence aside from LT's testimony is the DNA evidence. And so when the nature of the DNA evidence gets misrepresented in closing argument, I don't think we can rely on that to resolve a harmless error analysis.
Did that argument in closing by the prosecution harm the defense theory? Because wasn't the defense's presentation not inconsistent with the idea that this was Raley's DNA? I mean, the defense was saying, yes, it was Raley's DNA, but it got there through a reason other than a sexual assault.
And I may be misremembering this, I thought at some point, and they did not harp on it in closing, but I thought at some point the defense suggested it could have been potentially the brothers, which would have been an innocent source of DNA. But I agree in closing they didn't harp on it as much, but I still think, even though it may not directly contradict the theory that the defense used in closing, I do think it could still nevertheless influence the jury, because they've got this kind of different DNA test. I didn't know the Y-STNR DNA test existed until I read this transcript. So we have this understanding of what DNA means, that if your DNA is on it, it's you. But now we have this totally different test where it's not that conclusive.
Well, and I think, I mean, we attended a session on DNA evidence at a judicial conference last week, and like part of my takeaway from that was just the utter confusion. Like the scientists understand it, but when you translate that into a courtroom, it gets misconstrued. So how do we know that this is misconduct versus maybe a less than precise understanding of how this all works?
And I think the Metcalf case is helpful, and in that case it's a little different. They had one or two misrepresentations of the evidence. And again, whether that misrepresentation is intentional or not, I think it still causes prejudice to the defendant because it's being represented. It's his DNA, it's nobody else's, right? And that's not exactly true. It could be, I think, according to my math that I did in the briefs, 750 other people in Cincinnati. So I think when, again, whether it was intentional or a mistake aside, telling a jury that, when that's not what the experts actually testified, creates a problem, especially in a case like this, where you have the testimony of the alleged victim, and they've already decided not to believe her, it would seem on at least one count. So I think the DNA evidence becomes more forefront in a case like this.
Can you
Do you-
address, sorry, go ahead.
I was saying, do you believe that the statements and closing arguments stand alone as being reversible error?
I do think that's a closer call. I think they can. Now, Metcalf, to be honest, is an unreported opinion, and I've only found one case like that. So I think it can, but it would be close. I do think it's even more important under the harmless error analysis for the first issue, which is the excited utterance issue.
But on the excited utterance for the harmless error, it needs to be testimonial, is that right?
That's not how I interpreted it.
In order for the confrontation clause to kick in?
I'm sorry?
In order for the confrontation clause to kick in?
So I understood the confrontation clause to be a different analysis for the excited utterance. It has to,
Okay.
one, come in under hearsay, but then it separately has to
Okay.
survive Crawford. I would argue that it doesn't. Yes, she's having a phone call with somebody else. She's not talking to law enforcement.
So
But,
you're focused on the hearsay part of it?
and I do think the Crawford issue alone can resolve this issue because she's,
But
Yeah.
how is it a testimonial, like, she's not being interrogated by law enforcement, she's having an independent telephone call with someone else, and we just happen to have a memorialization of it through the body cam. Like, how does that implicate Crawford and Constitution and the confrontation clause?
I think under the test where her statements are supposed to be testimonial, right, which would be she's interacting with the police. While she's not talking to them, I think it matters that she's walking down the hallway. She's just opened the door. She's let them in her house. She's looking at them. She knows they're talking to her daughter. She's having a phone call within like 2 feet of them. So I think there is some awareness that she knows her phone call's at very least being listened to by law enforcement, if not recorded on their body cam. And if you take it out of the testimonial test to, I think it's the objective witness test, which would come in if the court were to determine she's not actually talking to law enforcement, then it comes, is she aware that her statements could be used in a court setting? And I think she does. Again, she knows that they've been called. She lets them in. She talks to them. I mean, her interaction's a little bit odd because the police are trying to talk to her, and she's trying to talk to her friend. So they're trying to engage with her. She knows this is all being recorded. And so I do think that it works under both of those tests.
Can you address the plain error issue with regard to the closing argument? I mean, these statements by the prosecutor were not objected to, right?
They were not. So it is a plain error analysis. And this is where I think it comes down to the quantity of statements, because in Metcalf, it's 1 or 2 misstatements, but several statements consistent with the evidence. And in this case, we have the exact opposite. I think she had 1 statement consistent with the testimony of our experts, and I think 9 statements that were not.
Does
And
the one explanation that's representing that the DNA was consistent with Rayleigh, but not necessarily his, does that undo the other statements? Does it affect the prosecutorial misconduct that you're alleging at all? Like, how do we weigh the fact that there was one correct statement and then the others that weren't maybe fully reflective of the evidence?
I don't think it impacts the analysis of the other 9, right? Because the jury is still hearing the other 9. They're hearing them repeated. They're hearing it's his DNA, it's nobody else's DNA. And that being told over and over again is going to associate them with, like, this is one of those definitive DNA tests. That means it's his, right? But that's very directly contradictory to what the experts testified. So I don't think the fact that it was said correctly once or twice undoes the other 9 times.
And I don't have the closing right in front of me, but beyond not objecting, did defense counsel raise in any manner the fact that that was just wrong, that mischaracterized the expert's testimony at
No.
all? Okay.
No, Judge, he didn't. But again, I mean, he left his DNA on the body. The only reason his DNA was there is because he put it there. It's his DNA they found. The only other profile is Rayleigh. That's her and him, that's it, not mom, not brothers, not sister, her body and Demetrius Rayleigh. We have Demetrius Rayleigh's DNA on the kit. We have a profile for Demetrius Rayleigh. So these are very definitive statements that would be in line with the standard DNA test that most of us are familiar with. And this is a very, very, very different test. And if the court has no further questions, I will take a seat.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, if it's okay with the court, I think I'll start with the second issue first. I think the thing to keep in mind here is that this is argument. Of course, it was the state's theory that this was his DNA. And I think that there was a tremendous amount of evidence, cross-examination as to the reliability or to the limitations of the DNA test in this case. And I don't think that there was any intent or any effect of the prosecutor misleading the jury at all in this case. I think once it was established that there were the limitations of this DNA evidence, I think that the prosecutor just kind of used a shorthand saying this was his evidence because that was our
Or
theory.
exaggerated the
Well,
significance
I-
of that.
I
I
think
mean,
it was-
I think that's
yeah,
the issue.
right,
Like,
yeah.
I realize it is argument, the jury's
Yeah.
instructed that this is argument, but there is a concern about overstating evidence, just like there is in any trial. And maybe, going back to my earlier question, maybe he didn't understand it, like, that's possible, but, like, I also don't think you can exaggerate evidence.
And I think also another aspect to consider is that it was the defense theory that it could have, the DNA that was found could have been placed there innocently. And I think that the reliability of the test doesn't go to the question of whether there was an indirect transfer or anything else. It was the defendant's theory of the case. So I think that militates against finding that there was any prejudice in this. In light of the other evidence, the defendant's testimony and the strange statement that the defendant made when he was questioned by the police that LT shouldn't have been permitted to wear leggings around him, and she was wearing those leggings on the morning of, indicates a sexual attraction there that also corroborates the victim's testimony in this case. So I think taking Metcalf, as it's been discussed, was not a plain error case. I don't think we can say that there's plain error here, especially there was no other suspect here. I mean, there was like, if there were 738 people in the greater Cincinnati that this could have been, it's kind of like the prosecutor was putting the puzzle together. I mean,
Well, counsel, there was the one statement made that the mother's DNA, the brother's DNA, the sister's DNA was not found, and there was no testing done for any of those individuals' DNA. Isn't that right?
That's correct, Your Honor, because it's, well, as explained in it's the BCI's practice, once they find DNA in the rape kit, not to go further. But I don't know what we can make of the fact that other people were not excluded. But I know that the testing that was done was a male profile, and there was a 1 in 1,506 chance that it was, that was not the defendant, I guess is the way to say it. And in light of the other testimony, I don't see how we can say that and those aren't like lottery odds, but at the same time, it's still pretty strong evidence. I mean, even if it's not conclusive, it does pretty strongly suggest that what the victim said was correct, and it corroborates the defendant's own statement that he was strangely sexually attracted to this 12-year-old girl.
Counsel, what do we make of the fact that the jury acquitted Rayleigh of the tampering count? Does that reflect some disbelief on the jury's part of LT's testimony?
I don't know how we can say, it's always tough to know what a jury determines. I mean, I would note that it might not have been a credibility problem with the tampering case, but there were some inconsistencies in what the state's witnesses said. So I don't think it's necessarily that they didn't believe LT when she said bath versus shower or all that. I think it was honestly, they were just too uncertain to find guilt beyond a reasonable doubt, but I don't think that was necessarily a credibility determination. As for the excited utterance, I think the case law, Jones and Turner, indicates that that the triggering event can be the revelation of these of allegations. It doesn't necessarily have to be a witnessing of the event itself.
Counsel, same question to you. I know we have these two cases from the Ohio Supreme Court that reach kind of different outcomes, but is there any sort of guidance that we have or test or factors? Like, how do we decide what the triggering event is?
I don't know, Your Honor. It does seem to be all over the place, but I think that in this case, it's a bit simplified because I think, as Judge Bergeron suggested, that there's a harmless error analysis that has to be done here. And the statement of LT's mother in this case was that she believed her child, not that it happened, or not that not that she had any insight as to the details of the offense. She just stated a general statement that she believes her child. And I just don't think that in light of the other evidence in this case, that could be deemed prejudicial. In my view, this isn't really a close case. I mean, I don't want to overstate the DNA evidence, but we have credible victim testimony. We have DNA evidence, and we have the defendant's statements that indicate that it could be, that indicate guilt. I'll put it.
But then, like, what's the point in introducing this to begin with?
Well, I understand, Your Honor. I don't know if it was piling on. I mean, I wouldn't think it was. It's just, it was kind of and part of it was, we were showing the body camera, and that was just something that the mother happened to say at that time. I mean, maybe it would have been better for it to have been redacted, but she certainly wasn't saying this to the police. She wasn't saying it in reference to any questioning, and it seemed to be entirely spontaneous. She was talking, when you watch the video, or if you haven't already, it's a chaotic scene. She is just absolutely out of her mind with anger and, just concern for her child. And I don't think there's any, I just don't think that spontaneous statement was anything that would have tipped the scales one way or the other.
And counsel, am I correct in recalling that the entirety of the body-worn camera footage was played for the jury?
It was, Your Honor.
It's
yes.
about 15 minutes long or so?
Well, there are like blank parts, but yeah, you know how these things are. It takes a while for it to get going, but it's just a few minutes long, and it's an isolated statement in the context of the entire trial. It was really, I would say that it was inconsequential.
And the officer interviews LT as part of this,
That's correct, Your Honor.
and that was also played for the jury?
It was, and her statement was consistent with her trial testimony.
I have a few questions. Can the triggering event can there be more than one triggering event? And then my follow-up question to that is, can it be cumulative?
Yeah, that's a good question. I think there can be more than one. I don't know that there was here, but there can be, a series of revelations that might, for instance, my child's been killed, and then, oh no, and then you find out it was the father who did it, for instance. Yeah, I think they can be cumulative, because I think that would increase the excitedness of the utterance. It would just increase the veracity of what the statement that's made, because the excitement would be that much greater.
And then with regard to the statement that's embedded into this video footage, that was played as video footage, right? Not played for the purposes of the event.
Right.
Of the statement, that is.
Right.
Other than the presentation of the statement within the video footage, is there any argument or any other use of the statement within the trial court proceedings?
Your Honor, I reviewed the transcript the entire transcript over the weekend, and I found no other reference to it at all. It was a completely isolated, spontaneous statement that wasn't harped on by the prosecutor in closing or at any other time.
Okay, and there wasn't any questioning, she never testified. Okay, thank you.
All right. If the court has no further questions, I'll the rest of my brief and just ask that the conviction be affirmed.
All right, thank you.
Thank you.
Thank you for your argument.
I want to go back to the tension between Jones and Smith, because I do think it makes sense to treat a confession differently than other types of statements, right? Because the law, think about admissions against interests or co-conspirator statements, right? Other rules of evidence take into account that when a person says something against their interest, whether it be a confession or some sort of inculpatory statement, we do treat those differently than other types of statement, under the idea being nobody would say that. Nobody would come up to their wife and say, I just murdered the lady that's on the news.
Well, counsel, to your point, earlier you had said that it was a hearsay within hearsay statement, and to your point then, the statement against interest exception would apply to the original confession.
Right, right. And I think when we're looking at, well, to your point, we don't have a clear-cut rule that tells us how to decide these, right? So we're left with, from what I can read, Jones and Smith. And in Jones, they focus on this, thus Smith is distinguishable because Jones, unlike Smith, told Dolores that he'd killed Yates, and Dolores' out-of-court statement related to that confession, right? And we know the law treats something like a confession differently than it would treat normal hearsay. So I think that lends to this idea that Smith is the case that applies to the case at hand, not Jones. Jones should be read to being very specifically limited to confessions.
So what do we do with, do you agree that there's, other than the playing of the video and the statement within the video, there's no other use of the statement within the trial court proceedings?
I agree with that.
So what do we do with that?
I think, again,
Because really what your argument is, was the playing was enough.
I do. I think a mother vouching for the credibility of her child daughter when the case, due to COVID and other reasons, doesn't go to trial for a substantial amount of time later, and the mother's not available for cross-examination, I think a statement under that excitement that the mother believes her child is really, really important. I mean, if I'm a jury and I'm trying to decide, and all I have is a testimony of this child, and then when this, whether,
Now, the state argued that there was more than that because there were certain statements that were made by your client that could be read to be sexual attraction.
those weren't harped on, I don't think that much either. In closing, I don't know that saying she shouldn't wear tights is enough to convict somebody. I think her testimony really was significant to the jury. It had to be.
Mhm.
And again, that's, I think the mother's vouching of the most important witness in the case really matters. I think it's going to influence the jury that the mother was upset. And I think that's one of the things, too, that cuts against the state because the mother's left from work. She's heard this horrible accusation. She's reacting in the minute, right? She has to be for it to be an excited utterance. And I think when you watch the video, it is clear that she's very upset. But who knows how that would have happened over time? Maybe over time when she asks her daughter more questions, she starts finding holes. Maybe when she has time to think about it, she finds more holes. And that actually reminds me of one of the arguments I made. I think when you say something like, I know she's not lying, you're making a credibility determination. I think that requires the objective reasoning that's outside the bounds of an excited utterance. Because you're having to think about who is he, what's he like, how long have I known him, is this reasonable, this is my daughter, does she lie? You're having to process a lot of information and come out with a conclusion. And I think that's that objective reasoning that, again, takes us outside of the excited utterance.
But I'm also hearing you say that, and maybe you didn't intend to say this, but I'm also hearing you say that because of the mother's relationship with both her child victim and her boyfriend defendant, that gave a gloss to the statements of credibility.
It could
Do you understand what I'm saying?
Yes, I think to the jury, they're not going to see that, right? They're going to see an upset mother believing her daughter, end of story. We have no information about the mother after that, right? And I think if you're a mom and you're confronted with this story, your first blush probably should be to be on the side of your child. But maybe over time, right? Maybe if she talked to her daughter a few times and she was around for testimony, maybe some other conversations would have came out.
Understood.
We just don't know because she didn't testify.
And I'm not hearing you to ask us to make some sort of broad sweeping rule. You're really asking us to look at that statement under the circumstances of this case and under what you're characterizing as the limited evidence that was against your client.
Yeah, very specific rulings in this case.
Thank you. I
Thank
don't
you.
know if there's anything further from the panel. All right, thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a great afternoon. Good morning.
Good morning.
State of Ohio versus Brown.
Good morning.
Good morning.
I'd like to reserve 4 minutes if possible.
All right, whenever you're ready, you can start.
I'd like to start with some language from the Rahimi decision, which was decided after the state of Ohio had initially submitted its brief that dealt with, as I see it, a pretty on-point determination of the issue that is also the question before this court. The Rahimi court says that when an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. The modern regulation was by no means identical to the founding era regime, but it did not need to be. I think here the lower court made a determination that someone who is indicted, merely indicted with a violent felony, does have a constitutional right to carry a firearm, and the lower court also found that the state did not meet its burden in justifying that.
And I thought Rahimi is interesting because in your reply brief, you're focusing more on the concurrences in Rahimi than the actual decision. And I was curious, what is the state's perspective on the standard, because I didn't see that in your reply brief, overlaying Rahimi on Bruen?
So I think the Bruen, the big question I think going into Rahimi at post-Bruen is, I think it was conceded by both parties in that case that the focus on that case was whether or not the issuance or granting of a civil protection order, someone who is under a civil protection order could be allowed to possess a firearm, consistent with the historical jurisprudence. And I think the thing that was conceded by both sides there is that there was not going to be a specific one-on-one law that dealt with a civil protection order. That is to say that both sides had to go into it with the understanding of, well, this is going to come down to, what are we really asking here? Are we asking, do we focus on the exact historical text that exists that the state is able to dredge up, or do we focus on the constitutional principles? And while I don't think the majority opinion, I think the majority opinion in reaching its decision answers that, they don't lay out the answer to that question as explicitly as the concurrences do, which is, in fact, what the focus of courts should be when determining these historical constitutional issues.
Right, but there's multiple concurrences and they're pointing in different directions. So I'm not sure how those help us.
Well, I think, if anything, what the court can take away, not from the concurrences, but from the majority opinion, the language that I cited right there was from the majority opinion. And they did make a determination that these surety laws, which were used in 1791 and 1868 to dispossess people who were accused of violent crimes, serve a similar danger prevention.
But counsel, those statutes were particularized to a person. And the question that I have is whether the legislature, in enacting this particular statute, even made a legislative judgment that people who are indicted on felonies pose any threat, or if this statute was adopted by the Ohio legislature to be punitive in some way. Do we know?
I think, as I understand the law that has surrounded the Weapons Under Disability statute for over the years that it's existed in the context of Heller and the other Second Amendment jurisprudence, that the governmental interest in protecting people from the danger posed by those accused of violent crimes is the reason that we've enacted that statute. That is to say that I do believe that the reason that the Ohio legislature has adopted this disability for those under indictment is because they believe that they, just by nature of being accused of these crimes, pose some sort of specific threat to public safety.
And so your briefing doesn't address that. Where would we go to find that legislative history for this particular disability?
So I think for this particular disability, you would have to look at the previous regime of constitutional analysis as it's been analyzed under Heller, which would involve having to put forth some sort of governmental interest. But I think what's important for the purposes of this court's analysis is not just what exists today, but what existed at the time. And I think the citations that we cited below, as well as to this court, would indicate.
Yeah, and let me ask.
There's a real difference because the current Bruen regime directs us to look for a historical analog, both in terms of effect and justification. So we need to understand the current justification. Why is Ohio disarming people under indictment? And if they're doing that for some sort of punitive reason, That's much different in terms of looking for a historical justification than if they're doing that because they've made some legislative determination that everyone in that category poses a threat.
As I understand, and I'd have to look back through my brief, but I do believe there is analysis from sort of the old guard. I can't remember if it was this case or another case that we've cited, for example, the Carnes decision or the Hands decision from the Ohio Supreme Court that speaks specifically to weapons under disability and the general determination that I believe the language from the Ohio Supreme Court is that the reason for the existence of our weapons under disability statute is because the public believes that those people present an increased risk of harm.
And why would, let's say we accept that.
Sure.
As the justification, then why would surety laws be an analog? Because they permitted a particularized system where someone would come in and say, this person presents a danger, and then that person, if the court agreed, would have to post a bond in order to possess their firearms. So that regime is particularized. It does not result in disarmament, and it does not result in a crime. So the statute we're looking at is totally different. It results in permanent disarmament. It is not particularized, and it does result in a crime.
I think from there, what we have to ask ourselves, at least what the U.S. Supreme Court has said, is at this point we're talking specifically about whether or not there is something that is one-to-one that we can focus on. And when we're looking at the principles of what those historic laws are supposed to justify, I think that is the thing that is focused on. In other words, did the founders at the time of 1791 believe that it was constitutional to dispossess someone in order to, because they believed that that person presented a specific risk? And I think...
And let me ask you this, like, many of these cases focus on an evidentiary record where the state has marshaled historical evidence. And I don't see that in this case. I see you citing a couple of cases or several cases that discuss the historical record, but that's different than advancing an actual historical record before the trial court. Is that important? What is the state's view on that? Because the historical records in those cases may be different than the situation we have here, but we don't have an actual record.
I mean, the lower court, when we had argued them before, there was, and I think we did do our best to try and recite some of those examples. I mean, there's references to and specific citations to the specific historical surety laws that existed and when they existed, as well as references to, for example, William Blackstone, who was a historical scholar at the time. Is that what the court's referring to?
That's what I'm talking about, but there's a difference between, and I think this is what courts struggle with, is we're not historians.
Right.
But Bruin seems to require us to kind of act as amateur historians, but that requires a record being brought to us rather than what the state did here, which is cite cases that talk about records before those courts. Do you see the difference that I'm...
I do. I mean, I do, and I will say that in terms of citing primary sources, we have included those for whether it was the lower court or this court to consider. I mean, if you're talking about, for example, we cite William Blackstone in the Commentaries of Laws of England and the speaking about, the purposes of those surety laws. If the court is wondering, how best to interpret those laws in a historical context, I mean, I do think there is some requirement under Bruin for this court to draw some interpretations, but I think how you go about drawing those interpretations...
that's my question. How do we do that without maybe an expert on the state's part? Like, I don't know how we're equipped to do that.
Neither do I. I mean, I think that was part of the issue of the dissent, what the dissent
Sure.
in both Bruin and Rahimi has cited of, we're not historians, but to the extent that the court is looking to the parties in the record, is looking to the parties to establish a record and to make propositions of law and fact to the court, it should rely on those. So I guess to the extent that the court can rely on the parties to make that record and to accept those as truth. If the court, for example, if I were to present one historical source, opposing counsel was to present another or the same historical source that draws a different conclusion from two different legal scholars, it would be up to the court as who has to determine the law to make that determination.
Piggybacking on that question, and as you just finished stating, the court is relying on the parties, on the state, because the state has the burden,
Right.
to develop the historical context. At the time that this case was presented, Bruin was the law of the land, but the Rahimi decision coming out of the U.S. Supreme Court had not been released, right? And at the time of your reply brief, I believe the Rahimi decision out of the U.S. Supreme Court had also not been released, or had it?
It had been.
It had been, okay. But you're in the reply brief, so you can't really present new evidence, right?
Correct.
You have to rely on the record that was developed in the light of Bruin.
Right, correct.
Okay, so my question is this, because you can bring new evidence to us. The presentation was made under Bruin. Should we be remanding this?
I think, our position is that it needs to be, that the court should reverse and bring it back. I think in consideration of Rahimi, let me start by.
Do you understand my question?
I think I do, which is what I want to get at, which is why I'm going back. Nothing that our reply brief and our references to Rahimi don't, I think, necessitate a new record that we're putting in. Only, I think, we're offering Rahimi as furtherance of what our argument is. That is to say that these surety laws that were referenced, that we referenced below, that were considered directly in Bruin.
I understand what you did in
are
your
the same.
reply brief. My question is, I'm bringing you to a different space.
Right.
Okay? Let's call it an alternative space.
Right.
Okay? And at the time that the case was presented, you brought forward certain historical evidence, right?
Mm-hmm.
And whatever you brought forward it under the understanding of Bruin,
Right.
okay? So my question is, couldn't it be said that if you knew of Rahimi, that perhaps there would have been additional things? And I'm not saying that, so the question is, should this be remanded?
I would think
As an
that-
alternative.
Right. I do think that would be appropriate. I think that there were a number. I think there was about 5 or 6 cases that were pending before the U.S. Supreme Court, and in light of Rahimi, all of those firearm cases were sent back down and remanded for
But
consideration.
to follow up on Judge Ice's question, are you, as you sit here today, are you aware of anything in the historical record that you say, oh my goodness, now that Rahimi's here, I really want to get that in front of the trial court?
I would say that I am, as more cases have come out and more courts have had the opportunity to view these, I guess I would say perhaps aware of new information that I think it would be appropriate for a court to consider. Mm-hmm. So in that sense, I still think that what we have, I guess my position is that the court still had the appropriate record in order to deny the constitutional challenge. But if the question is, would I enjoy an additional opportunity to present more historical record?
Right.
As any party that bears a burden in a case like this, I would like to present more evidence for the court to make.
And my question is based on whether it's appropriate. I don't want to put the burden on you of saying, this is what I would have presented, because then the appropriateness is being determined at the appellate level, and thereby, in essence, bringing forward new evidence to determine the appropriateness of the remand. You understand what I'm saying?
I think so,
Which
yes.
would be very inappropriate, in my opinion.
Right.
So I'm looking at it, my question is just based on a matter of where we are, Prost Brewing cases, we know are being remanded because the burden got shifted to the state. It seems as if post-Rahimi cases are being remanded, but not with much analysis. So I'm giving you the opportunity to address that, because it seems to me that Rahimi has added a gloss that could arguably be substantive and not procedural, and thus, whether the state would be disadvantaged, in essence, by not giving the opportunity to present the historical context with Rahimi in mind when they only were able to make a presentation initially with Bruin in mind. And everything subsequent is then bound to what they presented with Bruin in mind.
And this goes
That was
back.
a long question.
You're right, and I think it goes back to what I was saying to Judge Bergeron, which is that I think where the focus, as I see Rahimi's shifting from less about the exact
Correct.
focus on the
Sufficiently
law.
analogous.
Correct, and I think, and it's referenced somewhat in our brief. I think, you know, if, for example, I guess just to maybe wrap up this issue, I think had I been able to, and I think it is somewhat argued in here, when we're focusing on the principles, there are historical principles that I think are relevant to this question of someone who's merely indicted for a crime. I think it's axiomatic that merely being, you know, accused of a crime has traditionally allowed the state to completely hold someone until they have, you know, put someone in jail on only the allegation that they have committed a violent crime, or to post bond, which obviously I think subsumes your Second Amendment right. That is to say, you're
It's
not
de facto disarmament.
correct. It would be de facto disarmament. So that historical record wasn't as developed below on the lower case because we didn't yet have the guidance that our focus should be more on the principles. Obviously, I think I could have presented, and I do think there is a long history of abrogating someone's rights, whether that's First Amendment, Second Amendment, their freedom of movement, based solely on that indictment. Those are the types of principles that I think underlie this Second Amendment challenge, and I think are relevant to the court's determination.
Counsel, I have a process question for you.
Sure.
These particular types of cases are unique in terms of the body of evidence that we consider.
Correct.
Looking to history and these historical analogs that we are collectively supposed to find, are these, this history, is this more like record evidence that should be in the record and the parties should bring it forward? Or is this more like legal research that we can go find on our own, whether or not it exists in the record?
So when it comes to my approaching of these motions, maybe it's just because I miss Heller now, but I take the U.S. Supreme Court at its word. In the Heller case anyway, when they were developing that original two-step framework and what it is they looked at in terms of that record of historical evidence, the U.S. Supreme Court, and I believe the majority opinion says very specifically, you know, the authorities that we are looking at are going to be, I guess, whatever the parties can get their hands on. That course, they, for example, looked at criminal cases that were decided around that time frame. They looked at newspaper articles. They looked at code sections that were around that time. They looked at the words of the Founding Fathers. And their reasoning for that, if you read the Heller decision as they examine the historical jurisprudence, was specifically because they recognized that the U.S., by nature of dealing with law under a sort of common law framework, Bill and stare decisis is building its law on the backs of what came before it. And so because the Heller court believed it appropriate to cite to the analysis conducted by other courts, looked at what those other courts have decided, I believe that it is appropriate to do the same here. And so we have cited to not only other cases that have examined the historical record, but we've also cited to newspaper articles, to the words of the Founding Fathers, to historical statutes in that way. I think part of the question when this case came by that I struggled with was, is it necessary to have, for example, an expert witness that would come in and, you know, testify to a court? Obviously, I think that would be helpful. I think that was addressed by the dissent in Bruin. They made the same contention that Judge Bergeron did, which is that we are lawyers, we're not historians.
All right, so this, what I'm hearing from you is that this is more in the domain of legal research, and that if we find a case that does the homework for us and, you know, sets forth some historical facts and sources, that we can rely upon that, whether or not you two in this particular record put forward some kind of evidence or briefing on those issues.
I think that was the analysis that was done in Bruin, and I also think that was the analysis that was done in Heller and the cases that came after. That is to say that I do believe it's where we're really examining a constitutional question that deals with the record of the United States, it's appropriate to consider this from a legal analysis standpoint. Obviously, that, I think, has its deficits, if the court wants to get the clearest picture it can. But I guess in terms of sufficiency and necessary, I do think this is more like a legal analysis question. Although I will submit,
It brings up an interesting tension because we are intended to be a court of review.
right.
So that raises an interesting tension in our, which is very different than the U.S. Supreme Court or even the Ohio Supreme Court and the roles that they play.
And I would agree. I mean, I think there's an overarching question about, where there is a record below, and the court below is relying on the record and making a determination of the
Correct.
record. Who is the one to be convinced by
Correct.
the burden that the state bears?
Yeah.
Is it a de novo review? I mean, previously, all of Ohio law would suggest that on these types
Right.
of constitutional questions,
Right.
the burden
But de
should
no-
be.
But de
should
novo
be.
usually is also law that's already been established.
Correct.
So, like, again, that tension of saying, well, we're going to create it here, rather than remand it on a record like this where the U.S. Supreme Court spoke after
Right.
the record of proceeding was developed. But on that, thank you for your arguments. I'm going to reserve you 4 minutes. And Attorney Riley, I'm quite cognizant of, we will be giving you the same respectful, ample opportunity to fully present
Thank you very much.
your arguments as well.
Good morning, Your Honor. In this case, my client, Kendall Brown, was stripped of his Second Amendment right as a result of being indicted on a single-count robbery indictment.
Counsel, do we know why the Ohio legislature has chosen to do that?
Has chosen to put people...
Why? Yes, why?
We're very unique in that way. I believe there's only 2 other states. I believe it's very, very limited, the amount of states that actually place those under indictment, under disability, ad hoc for the entire class. Super common for most courts to place people under disability or the equivalent of that as a condition of their bond, depending on the facts of the case, the evidence.
But then that's a judicial finding based on the particular facts of the case.
Correct.
In this case, he was released on bond. What were the restrictions on bond?
He was placed on electronic monitoring
Okay.
and had to post a monetary bond. I don't know that offhand, but he had to post a monetary bond, and he was placed on electronic monitored house arrest.
So should we interpret that as a judicial finding of non-dangerousness?
I would ask the court to take note of the fact that at no point at my client's arraignment or at any subsequent hearings did the state ask that the court make a condition of his bond, no firearms. And he was
And
never
that was
informed.
available, that's a procedure that's available?
Absolutely.
And did they object to the EMU?
Did the state object
Did
to
the
the
state
EMU?
object to that?
No, I believe the state probably requested the EMU. Typically, most people, I would say the majority of those who are out on bond are not on electronic monitoring. That is a further restriction placed on those who are out on bond.
Well, I guess where I'm going is, like, if they felt like this guy was super dangerous, they would have requested more than EMU, presumably.
I think we can make that presumption.
Yeah.
But counsel, this firearm, as I understand it, was found because officers came out and conducted a search of Mr. Raley's house, right?
Correct. As a matter of course, most of those who are placed on electronic monitoring, they have to register the address they're staying at. They're confirmed to be at that address via the GPS monitoring. And at some point, typically early on in being out on bond on electronic monitoring will send out officers to search the house for drugs, paraphernalia, firearms. It was during that search of his home that a firearm was recovered.
Going back to my original question, do we know why Ohio passed this statute? Do we know anything about the legislative history? Is this a punitive statute? Is it intended to punish people for being charged with something? Is it prophylactic? Is it because Ohio thinks that people who are under indictment for felonies pose a danger to the community if they have a firearm? Do we know why?
All I can do is make assumptions. I have not gone through the legislative history. I cannot answer that for you.
That seems to me to be a very critical inquiry, given that Bruin directs our attention to a justification analog. So we're supposed to figure out why the government is doing what it's doing today, and then look back in history and find something similar in terms of its rationale.
Yes,
And
justification, I apologize.
It would be helpful to understand what the current rationale is.
Sure. But it's not just a justification analog. It's also a procedure analog, the actual restrictions placed on the individual. It's an analog of the entirety, not just solely the justification. But I will admit, I do not have the legislative history, what was being discussed or debated, to place those under indictment, under disability.
Is that the state's burden, your burden, somebody else's burden?
I believe it'd be the state's burden, because they're the ones who have to create the analog between Ohio's Weapons Under Disability statute and history. So I believe not only do they have to provide you with the historical example, they have to compare that to today's. So if part of that comparison is the justification for why it came into existence, I believe the state would have to tell you why Ohio's came into existence and whatever historical analog they're bringing forth.
All right, let's assume that Ohio has decided today, in modern times, that people charged with felonies
Yes.
are dangerous, just based on the indictment. Why, based on Bruin and Rahimi, can the state not make that legislative judgment, given the historical features of law that allowed government to disarm classes of people?
I'll give a few answers to that. One, there's no judicial finding here. There's no due process towards that right being stripped of somebody. It's completely categorical. There's no particularization or individualization. I'll also quote from Rahimi, which, by the way, was a very limited decision. It was about whether the equivalent of a CPO can restrict somebody from having a firearm. That means that that individual went through process. They stood before a court. It was an adversarial process. Evidence was heard, and there was a judicial finding. None of that exists if the state legislature passed what you just,
I have a couple follow-up
Yes.
questions. This is an as-applied challenge.
Yes.
So obviously, what we have in front of us is quite significant because it's
Absolutely.
as-applied. The section of the weapons under disability that's at issue, the language in there is felony of violence. So when we're looking at the legislative intent or policy, what do we do with the language? It's felony of violence.
I'll also note, it would also, if my client was under indictment for a drug charge, it would have the same result, whether it's violent or.
But it's the
felony.
A2 that's being argued here.
Yes, Your Honor, I would just
Okay.
make the point that it would apply, my arguments would apply towards both those disabilities. As to
So I'm trying to understand why we need more, and what more would we need besides the language of the statute that it applies to a felony of violence?
I apologize, I'm not understanding.
Why would we need more to determine the intent and the why and the reasoning on why an individual Second Amendment rights would be abridged during indictment period when they're indicted under a felony of violence?
Are you going off of Judge Kinsey's point about the
Correct.
justification?
Yeah, I'm trying to
of
understand, yeah.
legislative history?
Yeah, I want you to,
I don't necessarily believe it would be necessary. However, if you are trying to create an analog between, for instance, surety laws and weapons under disability based on pending indictment, I believe that Judge Kinsey's point about, well, is this purely punitive, or, for instance, is this a public safety concern, I think would be relevant. But I don't believe the court needs to know the justification behind the Ohio legislature when they passed the weapons under disability statute.
Counsel,
well,
why
the
is
section that we're
that?
talking about, the felony of violence.
Well, Bruin, the framework of Bruin says we have to look for two things in the historical analogs. We have to look for effect, what it's doing, what what impact on Second Amendment rights the law has today and historically, and then we have to look for a justification analog today and historically. We can't do that if we don't pin down what today's effect and justification are and then look backwards to find something similar. And it doesn't have to be a twin, it doesn't have to be one for one. But we've got to understand today before we can find yesterday.
Fair enough, and I believe at this point, based on the record before you, the court would just have to make the assumption about why the legislature included those under indictment under the Weapons Under Disability statute. So it very well could be purely punitive, or it could have been for public safety concerns. And I don't have that answer for you. I believe it would be the state's burden, given it is their burden to create the analog between today's law and the historical analog.
I appreciate you responding to both of our questions. I have another follow-up question based
Yes,
on
Your
your
Honor.
responses to Judge Kinsley's questions. You seem to be raising a due process sort of argument, and I noticed it also in your brief,
Yes.
where you talk about due process, and then about 2 paragraphs later, you talk about notice, the
Yes.
lack of notice.
Yes.
Do you understand what I'm referring to?
Absolutely.
Okay. I'd like to understand that more from the, because I'm trying to understand how this was developed. We've got sort of a nuance in this case. I don't know if you're aware, because there was a motion for sealing, which
Yes.
was granted.
Yes.
So it's created sort of like a little nuance here. But, so I'd like to understand how that was developed below, that due process idea, that notice idea, because that seems to me to sit separate and apart from Bruin.
Yes,
Do you
Your Honor.
agree, first of all, that it sits separate and apart from Bruin and Rahimi?
Yes, Your Honor, I don't believe that they made the due process arguments. The Supreme Court made those due process arguments in Bruin or Rahimi. That is something I bring forward to this court.
And was it brought forward at the trial court level?
Yes, Your Honor, I made that argument to Judge Jenkins at the hearing.
Okay. Can you, just,
Absolutely.
give me a little bit more context to that?
It's, well, the fact that, I'll start by saying this. I believe out of all the weapons under disability litigation, post-Bruin and Rahimi, that the pending indictment disability is the most unique and straightforward. In that, it implicates a lack of due process afforded to, in this case, my client. Whereas, for instance, convictions of adults for felony violence or felony drugs, or adjudications for juveniles for felony violence or drugs, those individuals lost their Second Amendment rights as a result of receiving significant due process. They had to be convicted or adjudicated beyond a reasonable doubt. It was through an adversarial process. Rules of evidence applied, hearings, and a
But this
judicial
is just,
determination.
this is just another way, like, correct me if I'm wrong, but this is just another way of framing the argument that there hasn't been a judicial finding because it's simply an indictment.
Correct.
Is that what you're saying?
Absolutely.
Okay.
And that because of that, there is this due process implication.
Okay.
That, think of what it takes for someone to be placed under indictment for a felony of violence. It's a result of a grand jury indictment. At that grand jury, there are no rules of evidence. Hearsay is allowed. It's, the state has no duty to provide exculpatory evidence to the grand jury. The grand jury doesn't have to reach a unanimous decision. The grand jury, the individual who's going to be placed under indictment has no ability to participate. It's non-adversarial.
So basically, you're saying that the probable cause determination coming out of the jury, the grand jury, is not sufficient and not.
Correct.
Okay.
And that there's no analog to that at all.
Okay.
Closest the state comes, in my opinion, is the surety laws and bail conditions. The surety laws, as the court during Mr. Wessel's time indicated, those surety laws were due process. Those individuals were provided due process. They stood before a court. There was a particularized determination. That individual who might lose their Second Amendment rights had the ability to present arguments and evidence that they needed a firearm for self-defense. All these procedures, all these things that went into the judge or magistrate making a particularized decision do not exist in the case
Counsel,
before you.
if a person receives a bond condition that disarms them.
Yes.
And they subsequently possess a firearm in violation of that bond condition, are they charged with a different crime under the Weapons Under Disability statute, or are they charged with this same A2, I think it is, section?
There would be two ramifications. So if someone is out on bond, and actually my client is the perfect example. My client was out on bond for a robbery. He was, conditions of his bond were a cash component he had to
And
pay.
it was an ag robbery, was it not?
I believe it was an F2 robbery. I apologize. I believe it was an F2 robbery. It might have been an ag robbery. Either way, he was out on bond for a cash bond in EMU. There was no condition there was no condition of his bond about no firearms. So let's assume that there had been. Let's assume at his arraignment he had been told, as a condition of your bond, given the state's request to make this condition, a condition of your bond is that you may not possess firearms. And then the same fact pattern plays out. He's found to have a firearm in his home. There'd be two ramifications. One, he would have been charged under this Weapons Under Disability statute, the A2. But two, Judge Jenkins, at the request of the prosecutor, could have revoked his prior bond.
Sure. Yes, I understand he would face bond revocation. But
Yes.
is there some other subsection of the Weapons Under Disability statute that would trigger a charge for violating a bond condition? Is there a separate section, so he's still going to face an A2 charge in that circumstance?
In the
Even with that particularized finding?
No, Your Honor. I apologize. He would face a new charge under Weapons Under Disability because he's under indictment for that robbery.
So that's going to happen regardless of whether there's been a particularized finding?
No, Your Honor. By a particularized finding, are you referring to if the judge or magistrate had made that a condition of his bond?
Yes.
Okay, if the judge had made that a condition of his bond, but this A2 section did not exist. Let's say Ohio did not place those under indictment under disability. In that case, he would only be facing bond revocation. He would not be facing a charge under the Weapons Under Disability statute.
Right, but what I'm hearing from you is that there's no other subsection. There's not like an A8 that says you violated a condition of your bond
There's
that
not.
disabled you.
There is fugitive, under indictment, and then adult convictions of violence and drugs and juvenile adjudications. There's no bond condition violation, Weapons Under Disability.
All right. Would you agree that A2 would be constitutional as applied in the circumstance of a particularized finding in the bond condition setting?
So if A2 did not refer to being placed under indictment, but violating a bond condition, that would alleviate my concerns about due process, given that that would be at a hearing where the accused is afforded the right to counsel and to argue against that. I believe that would have much less constitutional implications.
And would
than
it
its
fit
current
within
stance.
the Rahimi framework, given that there had been some determination that the person posed a threat?
If that determination was made. Quoting Rahimi, rather we conclude only this, an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed consistent with the Second Amendment.
Well, isn't threat to public safety a required consideration at the bond setting?
It absolutely is.
So there is a way for the state to achieve its objective under A2 constitutionally.
If their concern is public safety, then yes. They just have to make it particularized to the individual, and that individual must receive some degree of due process before that condition is placed on them. I think that would alleviate the state's concern. If they are actually concerned about my client, Kendall Brown, carrying a firearm, they would have to put forward that argument at a hearing that my client's present at, that my client's counsel's present at, and that my client can participate in and argue against the state's argument. But I believe that would alleviate the state's concern if their primary argument is those under indictment pose a risk to public safety.
And that would fit within the Rahimi framework.
I believe it would, again, if a credible threat to the physical safety of another or public safety is demonstrated at a hearing.
And we don't know if that would be the case with respect to Mr. Brown because that inquiry never took place in his case.
Correct. That condition of bond was never requested by the state at his arraignment or any subsequent hearing. I'll just note a few more things, and I believe we got through the two analogs the state's putting forward that I think match this pending indictment disability the closest, that being surety and bond conditions. But I'll just note that I don't think Rahimi does as much legwork as the state believes that it does. Rahimi was very narrow. I'll quote from Judge Gorsuch's concurring opinion. "We do not decide today whether the government may disarm a person without a judicial finding that he poses a credible threat to another's physical safety, nor do we purport to approve in advance other laws denying firearms on a categorical basis to any group of persons the legislature happens to deem, as the government puts it, not responsible." This is a complete rejection to putting an entire class of people without any judicial finding, without any particularization under disability. That's why I believe that the pending indictment disabilities are unconstitutional. If the court has any further questions, otherwise I submit.
I do have one more. So just to clarify, the remedy that you were seeking below and what you want us to uphold is just an as-applied unconstitutionality finding,
Absolutely.
not to take out the entire statute.
I would ask the court to take out the entire statute regarding pending indictments. That limited purpose, that limited class under the Weapons Under Disability statute, placing those under indictment for a crime of violence under disability.
Has the Attorney General been notified of that request?
I do not believe so. I have not.
Shouldn't they be present if we're considering invalidating a state statute?
Yes, Your Honor.
Thank you.
Thank you for your argument this morning.
Thank you very much.
All right, I'm going to try to keep you to your 4 minutes, but we'll see how that goes.
Thank you, Your Honor. I want to.
Sorry, Mr. Wessels, but I'm going to interrupt before you
Okay.
start.
Right.
Just a quick question. Do you agree with the point that Ohio is one of only 2 or 3 states that have a statutory regime like this that disarms people under indictment?
I mean, I would disagree, but it would be based on my speculation. I haven't done like a 50-state survey
I mean, because Judge Jenkins found that I mean, he decided in his decision that there was only a couple states. I just want to know if you have a basis to conclude that he's wrong about that.
I think looking at, as I remember looking through some of the states, there is, now I would only be speculating.
Okay.
I think the process of our relief from like a specific set of disabling conditions is different than other states. Like I don't think that our framework matches one-to-one with other states, to
Okay.
where I would say it's only 2 other states that have a similar framework that also do something similar. But I would only be speculating as to what other states do. To answer your question, Judge Kinsley, I wanted to make sure that I was correct on this. And so the State v. Carnes case that I cited earlier, that was 2018 Ohio 3256. And in that case, they did specifically compare the legislative history of our Weapons Under Disability statute with its federal analog and determined that the reasons for the same, specifically, and I'm quoting from paragraph 15 here, they said that the statute was broadly to keep firearms away from persons that, in that case, Congress classified as potentially irresponsible and dangerous. And they do say that the focus is not on reliability, but on the mere fact of conviction or even indictment in order to keep firearms away from potentially dangerous persons.
Great,
And they
thank you.
They do go on to talk about how our statute went about in 1972, and that our reasons for enacting that statute were similar to the federal analog.
That is
So-
very helpful.
So I do think that the reason for our indictment-based disability is because specifically the Ohio legislature has made a determination, and they go on to talk about, I think the language from paragraph 16 says inherent in 2923.13A2, which is the same code section, is a policy decision made by the legislature that allowing weapons in the hands of individuals with disabling conditions presents an increased risk to public safety. So I think in that case specifically they were talking about juvenile adjudications, but the analysis for the reasons for enacting that statute are the same.
Counsel, I have a question for you, and I want to preface it by saying that you and your office are doing an incredibly competent job in this case, so I mean no
on the
offense. I mean no offense by this. But because this involves a constitutional challenge to a state statute, was the Attorney General ever notified of this case and given the opportunity to participate?
I have not made any formal notification of them for that purpose, no. I know that while I had some general conversations with people, I don't know that they were particularly notified and asked to participate or given the option to participate by our office in this circumstance.
And do you know what their practice has been in these kinds of cases?
I do not. I know that generally we have a practice of having them involved when they involve the Ohio Supreme Court challenges, but as to this particular challenge coming up to this court, they have not been notified of this specific challenge, and I don't know their practices. There's something I want to make clear about the holdings in Rahimi.
I'm going to give you 30 seconds.
Just, I'll say this, there was a representation made by opposing counsel, both that a judicial finding was required, and then he went on to say in the concurrence that that was an issue not presented before the U.S. Supreme Court. My proposition is that that question was not decided and still remains open. That is to say, if the Ohio Supreme Court said, you know, we find that chocolate-flavored ice cream is delicious, I wouldn't take that to mean that either it's the only delicious ice cream flavor or that vanilla is not delicious. I think those are, I mean, it's an open question before this court. The Rahimi decision did not purport to foreclose and say that the only time someone may be dispossessed is if there's a particularized judicial finding. I do think that is the goal of and the purpose of the legislature, and so I think they
Understood.
made that decision.
All right, thank you so much. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. We wish both of you a wonderful afternoon. Burchika versus Ludi. All right, so first, let me clarify. Are you the only attorneys that will be arguing this morning? No, okay. You're welcome to sit here. That's what caused me to ask the question. No worries, no worries. I figured, let me clarify before we go forward. Okay, not a problem at all. All right. So, keeping in mind that there's cross appeal here, I'm going to ask up front in order to be able to manage all these lovely times with regard to both appellant and appellee, the division of time and reservation of time. So you don't have the division of time question, you only have reservation of time.
I do, thank you, Your Honor, very much. I'd like to reserve, since I'm an appellant and appellee at the same time, I'd like to reserve 5 minutes for rebuttal purposes, please. And I'll
Okay.
do my best to present my rebuttal arguments during that 5 minutes.
All right, thank you. And with regard to appellee, division of time and reservation of time, please.
I would like to reserve at least 5 minutes and.
Okay, so how are we, first of all, let's start with division of time.
I will be very brief, no more than 5 or 7 minutes.
Well, that leaves him 10 to 7, so let's be quite specific.
I will use less than 7 minutes.
Okay, so you'll use 7 minutes, and then you'll have 8 minutes.
Sure.
Okay. And you're both comfortable with that? So out of your 7 minutes, are you reserving any of that?
2.
Okay. And you'll be arguing first, right?
I'm arguing first?
It's a question.
Okay.
Are you arguing first or second?
I believe,
After the appellant.
I believe that, I agree. I would agree that I would argue first. You would argue second.
Okay. Okay, and out of your 8 minutes, what are you reserving? None. Okay. All right, now that we have that all settled, and I know what to do. Good morning again.
Good morning, Your Honor. May it please the court and counsel.
Thank you.
Thank you for having us today. Representing Mrs. Berchica, is how I pronounce it, and she's not personally corrected me, so I'm going to go with that.
Okay.
We've got several issues here, and I know we're probably doing a disservice to the court trying to, because I've presented several issues, and I know we're probably doing a little bit of a disservice trying to cram so much stuff into our 15 minutes, but then that's why we have the briefs, and I thank Your Honors for reading it. I want to start the issues, though, in regard to the very first issue that started the trial in this case, and the court understands the context, of course, as Ms. Berchica filed in municipal court $4,000 in damages to a rental apartment that got removed to common pleas court, and quite frankly, I don't think anyone's going to be shocked to see that it got completely out of control as far as litigation is concerned. But at the beginning of the trial, she attempted to present evidence on a claim for damages that exceeded the amount that I guess was in her small claims complaint. And the judge said, you can't do that. We're holding you to the small claims complaint. And that
But she
crippled her
filed a
case.
motion to amend the complaint that was denied.
That was correct. And I
Okay.
don't know that that necessarily, those has anything to do with her, then evidence of her damages for the claims that she was presenting. And I'm primarily relying upon Rule 54, of course, that says you're entitled to whatever relief you can prove. And there was no motion in limine, there was no pretrial ruling, she shows up for
But the trial court denied her relief, right? So if she presented damages of $1,000 or $1 million, if she's denied relief, like, why does it matter?
Other than, Your Honor, my understanding from reading the record, I wasn't at trial, was that she wanted to present additional evidence for additional support for additional damages, and the court just didn't consider any of that part. And that would have been, as I understand it, completely unamenable to a small claims complaint, because a lot of it had to do with...
Well, but like, are you talking about a new claim? Like,
don't think so.
I think that's the issue, right?
It could have been an issue, but I don't know that it necessarily was, because I don't think, my reading of the record was not that it was an additional, for example, a tort claim.
Right.
She wasn't all of a sudden saying, well, you also rear-ended me in the parking lot, or you hit me in the mouth. It wasn't any of that. It was based upon the totality of the circumstances.
So if it's the same claim, and she's just saying, I suffered more damages than I previously thought, but you still lose on that claim,
I don't think that it's the same thing.
why does it matter?
I don't think that it's the same thing, because I don't think it was a matter of more damages on the same claim. It was maybe different damages, different elements of damages for the same claims.
But again, if there's no recovery, like you haven't met whatever the elements are, you don't get to the last element, damages, without satisfying those first few.
Except, Judge, and this does take me to a certain extent to my second issue as well, is that Your Honor didn't say that you didn't prove damages. The trial court said, okay, you've got damages, but they're ordinary wear and tear, those that you were allowed to present.
Mm-hmm.
And so the trial court didn't say you didn't have the damages. I don't think there's any dispute.
Is this evidence in the record for us to review? Was it proffered?
I believe that she did. It's a gray area on what constitutes a proffer, but I think when the court made the ruling and Ms. Berchica did her best as a pro se litigant to say, this is what I want to present, and just said, no, you can't do that. That's the best proffer you've got, and I think it's sufficient to be able to say that it would have been other damages, it would have been other claims, and it would have been an excess, it would have been what was
So how do we know, though? I mean, looking in review, how do we know that it falls into this box that you're describing?
I don't know that there's ever, in my experience, ever a way to know for sure, other than you read the words, and I interpret them to say she was being very clear that, because the judge said, no, I'm not going to let you present any of that. And therefore, the trial judge knew what she was talking about. I think you can get enough of a feel from what she proffered, and she didn't call it a proffer, obviously, but what she said, I'm going to present this, and the judge said you can't do that. You would be able to judge that it would have been in the category of Civil Rule 54C, that it's damages that you could have been allowed had the evidence been allowed. And I also should mention, I think that not only would have been, to answer Judge Bergeron's questions, not only part of her case in chief, but I think she might have had a right to present it as a matter of offset and reduction of the other damages too. And there's a common law right to, you tell me you owe me what? Well, guess what? You owe me more than that, even if it's not part of the claim.
I mean, if
or
this
part of the
was in
defense.
theory, let's go with your characterization of the evidence as maybe showing further damage to the apartment than what she had previously described or what was in the record thus far. Couldn't she have used it for cross-examination in the testimony of, let's say, the contractor who came in and said, well, this is one of the cleanest apartments I've ever seen. I mean, couldn't she have shown the picture to him and said, what about this damage? What about that damage? I mean, that didn't happen, did it?
I think it did. I think from time to time, and I've tried my best to cite to the pages in the argument, is that where she was not allowed the evidence, not only at the beginning, but also when she tried to raise questions and ask questions on cross-examination about the same subjects, that she
But can
wasn't allowed to do that.
tell, like, what are these subjects? I think that's what we're getting at, like,
Yes.
and I realize the predicament that you're in, and I get it, but, like, we can't just, like, imagine,
You can't.
you know, this world in which there's all this evidence that we don't know what it is.
You can't, Your Honor. I think the best I can tell you is that when I read it and she started to present her opening statements and her pretrial statement, which outlined it all, and the judge then said, you can't present any of that. I can look to the pretrial statement she tried to file. I can look to her opening statement and see what she was trying to present. And Judge Kinsley just jogged my memory that a lot of it had to do with, as well, non-economic damages that she wanted to present along with the complaints she was making about the conduct of the tenant. And that's, I think, a direct offset of some of the claims that Ms. Ludi was making.
Well, isn't that outside the four corners of the complaint then? I mean, if she's saying, like, she caused me pain and suffering, isn't that outside of the rental contract?
Well, I hate to argue that, you know, in every contract, there's a duty of good faith and all that kind of stuff, and wish you're breaching that kind of stuff, because it gets into a very gray area. But reading Civil Rule 54C, you're entitled to the damages you prove, regardless of what's in your pleadings. And I think that's important, that for when a person shows up and they've properly filed a pretrial statement, and they said, here's my exhibits, here's my evidence.
Did Ms. Ludi have noticed that she was defending a pain and suffering case, or did she have noticed she was defending a broken rental contract case?
According to my reading of the brief, and I cited this in my brief, at her brief on page 11, I read that she conceded that that was all in her responsive pleadings, it was all up front, and there was no surprise or prejudice. So I think that Ms. Ludi has foreclosed that issue in its entirety in her own brief, for what that's worth. But then also, the point I raised is even for the damages that Ms. Perchica was allowed to present, the court found that it was ordinary wear and tear. And this is a weight of the evidence issue, I get that, and Your Honor's going to look at it and in the context of, in this case, we have a lease that says you're not allowed to smoke, you're not allowed to make alterations, you're not allowed to make adjustments, and at the end of the lease, you have to go through a walkthrough so we can all look through the thing. And Ms. Ludi violated every one of those. She
So
admitted.
doesn't that turn, in some sense, on the credibility determination?
To the extent that if she would have said, no, I wasn't smoking, I would agree with you, but she conceded she was smoking. To the extent she said, no, I didn't put those holes in the walls, but she didn't say that. Those are not credibility issues. It's an assessment after the fact of, is it ordinary wear and tear to smoke in a non-smoking apartment?
But the trial court says, the court finds the credible evidence supports Ludi, not Perchica, regarding the condition of the apartment. So the court has made credibility findings of that.
For some things, yes, Your Honor. No doubt about that. There's no doubt about that. And that was, some of that, though, went both ways, but I didn't get the impression any of that had to do with the physical damages to the property, because no one ever disputed you were smoking in a non-smoking apartment. No one can dispute that the reasons to have non-smoking facilities.
Is there a difference between agreeing that the individual smoked in the apartment and agreeing that that smoke resulted in certain damages?
I think yes, I think there's a difference, but my reading of the entire.
So isn't there a credibility, or isn't there a weighing of the evidence that's the determination made by the trier of fact on that causation as well?
If in fact, Your Honor, there was anything in the record where Ms. Ludi said, I didn't smoke, or my smoking didn't cause any smells, it didn't cause any stains, it didn't justify the landlord taking extra steps to clean a smoking apartment, that I wouldn't have had to if I wasn't smoking. There's nothing in the record about all that would justify that type of a credibility determination on those particular issues. Certainly, there were credibility determinations on all the, and I'm just going to use the feuding between the two of them that went on. That's apparent from the record about you yelled at me and you made noises and you did this, and that stuff is there's no doubt they went back and forth. But the property damages to the non-smoking apartment, the breach of the lease conditions for no alterations, the breach of the, we have to do a walkthrough, that stuff was never denied, and I think, in fact, was admitted. And that's what makes it difficult for me to say and to ask your honors to find that it was ordinary wear and tear under those circumstances, much
So you
less
have
to
about a minute
exclude it.
left, so
Yeah,
is there
that's
anything else you'd
unfortunate.
like to present to us?
That's unfortunate, and this isn't unfortunate, a constitutional argument. I would just like to mention to the court that a lot of the foreclosure of Ms. Berchica's claims came to this finding the court made about the voicemail from the one attorney to the other attorney about you can leave if you want to. And that was enforced as a contract against Ms. Berchica releasing her from the
Well,
lease.
was it enforced as a new contract, or was it determined to be a termination of the existing contract?
I don't know that I can see there's a difference between those two conclusions because they have the same effect. Ms. Berchica, you released the lease and therefore you can't claim back rent, you can't do any of this. Isn't that a new agreement? And if it is, the law of accord and satisfaction is very clear.
Is
If-
that what the trial court determined, though? I don't read the trial court's order to say it was an accord and satisfaction of the entire lease, but that it was an agreement to terminate the future obligations under the lease.
I think that's what she said, and I think that's the problem, because then there's no consideration for Ms. Berchica's part of it. What did she get from that? Nothing. There is no consideration. She got no benefit whatsoever, from the fact that, okay, I can't claim back rent against you, but you can claim back rent against me in the form of this retaliatory eviction and moving expenses.
Wasn't it a prospective agreement, not a retrospective agreement?
Boy, Your Honors, all I can say is from one voicemail, from one attorney to the other, you're free to leave. I don't know that making that jump to that conclusion, as the trial court did, is consistent with contract law. That you have to have clear and definite terms, a meeting of the minds. Courts don't get in and rewrite the contract for people. And that's what that's what the trial court, I think, did, is rewrote the email from one attorney to the other. You're free to leave if you want, as a release of one side of the lease, but not a release of the other. And next thing you know, she can't present her claims, but Ms. Berchica can. It should have either been two-sided or no-sided at all. That is, there's no agreement at all, and it was just nothing. It was just somebody giving someone permission to do what they had a right to do anyway. But it had a substantial effect on the rest of the case. And I know I'm probably well exceeded my time.
But I understand your argument very well. Thank you so
Thank
much.
you. And I'll save whatever I've got for rebuttal. Thank you.
Yeah. Good morning. I'd like to pick up where the appellee left off, okay?
Yes.
What I'm hearing in his argument is that the trial court made a determination that there was mutual assent to terminate the obligations of the contract. But at the same time, there were damages awarded that can only be awarded as a constructive eviction. So what do we do with that? First of all, do you understand my question?
I believe so.
Okay, so what do we do with that?
Focus on the relevant part, which is that my client was constructively evicted. It's irrelevant whether there was a meeting of the minds. The history of the case was such. My client was a single mother. She wanted out desperately. I believe there's testimony in the record that Ms. Berchica was excited to see her go. There was testimony in the record that her contractor, Mr. Bryson, showed up at some point in August and said that he could not perform services and do any lead abatement with somebody living in the property. And Ms. Berchica said she would take care of that. And I think the ultimate measure of whether or not Ms. Berchica agrees with whether or not she released her from the lease, despite her filings, one way or the other, her initial filing, the bulk of that filing of damages is for breaching the lease. So, I don't know what, I think that's it. She's the one that can't.
I think the
handle
argument is, as I understood it, is that there seems to be an inherent unfairness to release the tenant from the future obligation to pay rent based on mutual assent to terminate the contract, and at the same time to award damages to the landlord under constructive eviction. Is there an unfairness or a conflict in there, or tension that's created there?
I don't understand what it would be. If the landlord takes it upon themselves to act in a furtive, hostile manner that makes someone feel unwelcome living under their roof, to the degree represented in the whole case, it would have come out the same way. The property was worth what the property was worth up until late July, early August of 2017, when my client was notified that her child had an elevated lead level and expressed that concern to the landlord. The court's decision.
Didn't the trial
Yes.
court determine that the constructive eviction preceded the agreement to terminate the lease?
Yes.
And therefore, implied in that is that the constructive eviction was the precipitating event for the agreement to terminate the lease.
If there was an agreement. So Ms. Perchica in her filing says that there's no agreement. She sues my client, which says there's no agreement from her standpoint.
Well, the trial court found that there was an agreement, so we're bound, at least at this point, by that judicial determination of fact.
Okay. But again, I get back to the point, the property had negative value to my client at that point. At the point when she moved out in September, she'd already had an automatic bill pay, send the money to the landlord. She walked away from that money, not knowing if she would ever see it again, willing to pay another month's rent to simply not be under that roof and subject herself and her child to what was going on. She had to get out. She had to go pay a new security deposit. She had to go pay higher rent. She had to walk away from the rent she'd paid, and had no idea if she'd ever see her security
Looking
deposit.
at I understand the factual background, but looking at the legal interaction between these claims and the tension that Judge Zayas has highlighted between the two of them, at least as I understand the trial court's order, the constructive eviction occurred first, according to the trial court, and was the precipitating event for the decision to terminate the lease. Is that your understanding?
If I understand the way you're putting it, I believe the record shows that my client was inviting, simply trying to leave under peaceful terms.
In other words, but for the constructive eviction, the parties would not have terminated their rent arrangement.
Correct. Correct. My client was living there happily up until the lead investigation started by the city in
In
early
fact,
August.
wasn't this the second year of the lease term?
Yes. Yes, and in the court's decision, it even reflects that the parties lived amicably up until that time. They knew each other well.
So given that you're past your time,
Yes,
I'll
ma'am.
give you a minute. Is there anything else that you would like to present?
In terms of rebuttal towards
No, in terms of,
anything,
yeah,
denying attorney fees in a landlord-tenant case is an abuse of discretion on its face. The court found that everything that Ms. Perchica did emanated from this lead investigation, everything she did. She withheld the security deposit. That was related.
so
She
the
went on
the
a vengeful
withholding of
tear.
the security deposit in itself
Yes,
lends itself to statutory attorney's fees. Is that in essence what
it's
you're saying?
mandatory.
Okay.
Retaliation, constructive eviction, wrongful withholding, and all the other claims emanate from her desire to retaliate. Well, and I left out retaliation. All of it emanates from those things. They all emanate from one thing, the lead investigation, where my client opened the door because her child had elevated lead levels. That's it. And as the court indicated, she blamed my client for it, and she never stopped. Never. Still doesn't.
Thank you. In your opinion, what was the determination on retaliation made by the trial court?
Your Honor, I really don't have an opinion on that. You know, the scope of my representation has to do with the motion for sanctions and attorney's fees against Tate.
And
So-
no one's challenging that, right?
And my comments to you, Your Honor, would be very brief this morning.
because it's my understanding that
Well,
no one is.
you have 8 minutes to make your very brief comments, so.
And I will
I don't know
submit
that your
all the-
division of time reflects that.
And I will submit all the other legal arguments that are in our briefs to the court to read and to look over. But the sole issue that's before the court today, as it relates to Tate, is the decision that's striking Ms. Luddy's motion for attorney's fees and sanctions and denying sanctions and attorney's fees against Tate under Civil Rule 11 and Revised Code 232351.
But again, no one is challenging that.
I'm
So,
happy to go into more details.
I mean,
There is no challenge. It is completely
we're not going to grant
unchallenged.
relief on something that no one has challenged.
My argument is it has been abandoned, and therefore the court should affirm the
Is,
trial
Okay.
court's.
is Tate even a proper party to this appeal? I understand why he would want a voice, but is he even a proper party?
He has not been named an actual defendant. In this case, he was brought in on a post-judgment motion for sanctions and attorney's fees, so he's been considered an involuntary party, if you will.
And that has not been appealed?
It has officially been appealed. The notice, the decision was attached to Ms. Luddy's notice, but there has been no assignments of error in the brief. Therefore, we considered it unchallenged and abandoned, and therefore the court should affirm the trial court's final order.
Would it be appropriate to dismiss him from this particular appeal?
I think that'd be very appropriate.
Is that an action that he would request?
Certainly. Those are all the comments I have.
All right, thank you.
Thank you.
Being conscious of my time and your honors, I do think that you hit the nail on the head about the inherent inequity and unfairness in a one-way release of liabilities for things even that predated the you're free to leave if you want to leave. And on my brief, I did argue that in response to the constructive eviction argument, I mean, this court in that Burnside case, I think it was, it said that if the tenant remains in possession, she can't claim constructive eviction. And the JAL case, which I cited in brief from this court, where the defendant decided to stick it out and just kept the rent money, this court said there can't be a constructive eviction.
Well, she did ultimately leave, counsel, before the lease term ended,
And
right?
remember, yes, absolutely. Remember, though, she asked, can I stay for 2 more months? And that was fine with me. And then she tried to sublet it to someone else, which was fine with me, which also overlaps with the issues of the damages. I mean, the court gave, like, 20 grand in damages for emotional distress when there was no testimony that it was severe and debilitating. And then I'm sitting here asking moving expenses. Awarded moving expenses for a mutual agreement, if that's what the court found it to be. A mutual agreement to leave early. She would have had moving expenses if she had not left early. So why does she get a free move at my
Well,
client's
counsel,
expense?
as I read the trial court's order, it determined that the constructive eviction occurred first. That precipitated the agreement to walk away from the lease, which would not have happened but for the constructive eviction, and that's what led to the need for moving expenses, which would not have occurred but for the constructive eviction. Can you address that sequence of events?
Yes, and part of that, what I would have to inject into that sequence is the other side of the argument that she wanted to leave early anyway for other reasons unrelated to the lead issue, which we were described in the case as basically it was fake and it was false and it was just used as an excuse.
But the trial court didn't credit those reasons. So what do we do?
I think that if it's a matter of simple application of contract law, attorney says to one attorney she can leave if she wants to leave. The court either construes that as a contract or that's not a contract and you're both free. I mean, she left, fine, but you both are free to both pursue your claims but also the consequences of those claims. But if you're going to construe that as some type of an agreement
But doesn't
to
the
go,
constructive eviction, as I read the constructive eviction case law, it does negate the tenant's rental obligations once there's been that finding of constructive eviction.
once they've left, and I'm
Right.
citing from the Burnside case that if they remain in possession, they can't claim constructive eviction. But yet in this case, not
But she
only
did leave.
after 2 months and then got her rent back and then got out of paying future rent. And so
But
is it?
isn't that the right remedy? I mean, don't you need to address the constructive eviction? Doesn't it all come back to that? Not necessarily the voicemail?
Yes and no. Yes, that's clearly a very important part of it. I don't think that there's evidence in the record to support a finding of a constructive eviction, considering she never said, I can't leave here anymore, I've got to go. She stayed, she asked to stay, she asked to sublet it to someone else, she actually paid rent, and then they said, and they hated each other at that. I mean, I don't think I'm mincing, they hated each other's guts at that
So
point.
basically what you're saying is even if there was constructive eviction at some moment in time, that was negated by what occurred thereafter, to wit the 2 months and the trying to sublet. Is that the essence of your
I don't know
argument?
that there's any other way around that, Your Honor.
Okay.
That's certainly what it appears like according to the vast weight of the evidence and what was really going on here, as ugly as it was. And the last thing I can say other than, I
So
don't know
really,
how-
we have to determine as a matter of law whether your argument is correct.
Absolutely, that's a good point, Your Honor, very
Okay.
good point.
Yeah.
And then, obviously, I'm complaining about the fact that there's, I mean, nearly $50,000 judgment for a bad landlord and tenant relationship, and there was no evidence of debilitating emotional distress.
Well, the award of the punitive damages, we're going to be limited with regard to that. Now, obviously, if there is a determination on any of the underlying damages that shifts the calculus,
Certainly.
then that obviously then impacts the punitive damages. And
Certainly.
would you agree that that would
Certainly.
require remand for
I hate
redetermination
to
on the
say that,
punitive?
for as bad as this case went between the parties, but I can see that that could be one of the options. The court could also have the options of determining that it was not justified by the evidence and vacate it. It's just a fact of life and it's over. I can see that as well. But that also does tie it, and I'll finish up because I think I'm probably close to my time, is in the argument about zero award of attorney's fees for withholding the security deposit. I mean, I find it hard to believe that this court would say that it was an abuse of discretion in the vastness of this litigation, this much of which had to do with, I had a security deposit, you didn't give it back to me, that it was an
Well,
abuse
but
of discretion.
that's part of the whole, it's part of the whole conduct. And there is a statutory requirement for that, is there not?
There's a statutory requirement to consider attorney's fees, but there's also the case law is very clear that zero is justified under the law if that's what's reasonable, and that it would not be an abuse of discretion. I've cited several cases that in the scope of things, especially when it was mixed in with unseverable claims, that if the security deposit had not been withheld, the same case would have happened, except for maybe 3 questions. Did you have a deposit? Did you get it back? Why not?
But do we know that that's the trial court's calculus here? Do we know that's why the trial court reached the number 0?
I don't think that anyone knows for sure. No one asked for findings and conclusions at that point, just it was denied, filed the appeal, so I can't stand here and tell you that. I can tell you that when the court was after the fact brought up the motion for attorney's fees, still turned it down, and one of my arguments was exactly that argument, that that's subsumed in everything else. There's no human way possible to try to sever reasonable attorney's fees for withholding of the security deposit from the vastness of this entire case, and the judge agreed with me on that I'm not going to award
Okay,
attorney's
but
fees. So it could have
doesn't-
been.
But your argument goes to the calculus, not to the merit of the attorney's fees.
I think it goes to both.
So you
Your Honor.
first have to, you first have to determine the merits of the attorney's fees, and it seems as if the trial court somehow determined a negative on that, despite the fact that it was statutory.
I don't know that I would agree with that, Your Honor, simply because the court was given post-trial the opportunity to make that determination and said, I'm not going to, the trial's over, I'm not going to award you attorney's fees. And I don't know that I can stand here and say and read the trial court's mind that they did that
Let me
by
just ask you a
breaching the
very
statute.
narrow question.
Yes, Your Honor.
If you give me some case law citation that allows a trial court to circumvent statutory attorney's fees when it comes to the withholding of the security deposit.
No, there's no such case that I know of, to be very direct about that. But the ultimate result is justified. That is, no attorney's fees in a case that there cannot, the ultimate result is clearly justified under the case law, and it's almost a no harm, no foul. You want to complain that I didn't get my hearing on attorney's fees that I'm not going to award anyway? I don't think that that's, you know, the vastness of this case, that it does substantial injustice, or that the party, I think the rule in the appellate law is that she was not done substantial injustice by not letting her have a separate hearing on attorney's fees for the security deposit only, considering the vastness of this case.
All right, thank you so much.
Your Honors, thank you very much for your.
Thank you for your argument.
As to, you want me to go as to, in any particular order?
I'll let you go.
As to
Whatever
Mr.
whatever you'd like to do.
As to Mr. Tate's claim, there was a basis to file the initial appeal, but I would submit that it was not argued and is probably subject to being dismissed. And I wouldn't object to that based on the record here. With regard to what's just been brought up, there's not just one claim for attorney fees about a wrongfully withheld security deposit. It's a vengeful narration, this big, long history of retaliation against my client for cooperating
Right,
with the
but
lead investigation.
here's what makes it sort of interesting, is when you have attorney's fees, you can have statutory attorney's fees, and then you have discretionary.
Yes.
So you're going to have a difficult hill to be able to overcome on discretionary, but it seems quite different when it comes to statutory.
Right.
Now, your argument seems to be meshing the two,
My
but maybe I'm
argument's-
misunderstanding.
I think the focus of my argument in my brief is the having to do with the right to an attorney fee under the landlord-tenant statute for the violations of the security deposit, the retaliation, and the constructive eviction. Everything flows from that.
What was the determination on retaliation by the trial court, in your opinion?
That the landlord engaged in a escalating, continual pattern of retaliation, even after my client left the property, by following her to two of her jobs, by demeaning her in the pleadings. I don't know if the court wants to look at pleadings in terms of the context of what was said, but the court took judicial notice. In a way, they are judicial admissions. Ms. Berchica sends a subpoena to my wife to testify against my prostitute client and against me because I'm of a mental disorder. She sends a subpoena to her witness saying that something to do with my client's posing naked.
Let me go back to the
Yes.
attorney fee issue, because the
Yes.
only ground I see in your brief is for the statutory fees, not for any fees that might be awardable because of punitive damages, litigation conduct, Rule 11, anything like that. So the issue before us is simply the statutory fees. Is that correct?
Yes.
Okay.
I think they subsume, I mean, from my standpoint, in terms of where I stand for my client myself, I understand Your Honor's point that maybe it's some difficult hill, but when the dollar amount is zero and there's mandatory fees and the landlord initiates the action and none of her claims are taken well and the case takes up 4+ days in the trial court's courtroom, zero is a low number. And other
Understood.
courts have found ways to deal with it. The concept of the landlord-tenant statute, the philosophy of it, the spirit of it is that these expenses are not to fall on the innocent tenant. It's to protect the tenant. Everything's supposed to be construed in favor of the tenant. Landlord's got a proper legal way to evict somebody, and it's very simple. And when they go to the extent that's demonstrated here, the tenant, the burden, the cost of the burden doesn't fall upon them.
Okay.
It's supposed to shift. That's the whole
Understood.
point.
I have one narrow question for you. One of the arguments this morning that was made was that when it came to the intentional infliction of emotional distress damages flowing therefrom, that there wasn't evidence to support that, that the distress was severe and debilitating.
Okay, that's simply not accurate.
Okay, so what is the evidence in the record to support such?
The evidence in the record is a combination of testimony from my client, a city nurse, city lead inspector, a neighbor who saw my client have a visible reaction in terms of loss of appetite, loss of just becoming depressed and anxious, especially when she was under a simultaneous attack by the landlord. It affected my client's ability to sleep, to eat.
So let me ask the question even more narrowly.
Yes.
Because there's a causation to this.
Yes.
And so, you have a child that has been exposed to lead, the knowledge of such. So you have other stressors that are out there that are part of the record. What is the evidence that narrows, even if there's evidence that is severe and debilitating, that narrows the causation to the landlord's behavior?
My client's reaction when she was behaving in that manner, not contemporaneous to the issue with her child. She was trying to get help with regard to her child. That's what she was interested in. Her physical manifestation included fear, as testified to by her neighbor, Julie Broxick. She expressed fear of going home because of the landlord, fear of the landlord against herself and her child, being pursued to her job, right?
Those things wouldn't have happened just because of a lead test with a baby, right?
Exactly. They would not, if I understand your question. The court says that those happen. The baby has a lead, it's like a kid's story, but it's like the baby has a lead test. The hospital reports it to the state reports it to the city health inspector comes in, and then retaliation begins. There was no, everything was fine up until the lead inspector showed up.
And I think that's what makes it very difficult, is the proximity of everything, because it was the knowledge of the health issues with the baby were in very close proximity, let's say 24 hours or so, to the landlord's initiation of behavior.
Except the landlord knew that she was vulnerable because the landlord knew of that. She had very specific knowledge that that was in my client's mind when she then decided to go on.
Did your client,
escapade.
did Ms. Ludi testify to what the source of her loss of appetite and weight loss and fear and inability to sleep was? Was she able to explain what
Yes.
was causing this distress?
Yes, it's in the seventh volume of the trial testimony when Ms. Ludi testifies and Julie Broxick testifies, discerning the difference between concern for her child, which she could deal with. She was doing the cleanup. She was taking steps to mitigate the problem, so she had control over that. My client had control over that. She had no control over what she could anticipate coming next, even after she walked out of the door of the building.
Okay, so did she attribute the cause to the issue with the landlord?
Yes.
And so there's credible evidence in the record to support what the trial court found?
Yes.
And how does that fit within our manifest weight standard of review?
It goes to the court's, the weighing of the evidence that we've brought up here. The court is in a position to listen to the witness, to see how each side demonstrated themselves regarding that issue.
Is
Whether-
there any evidence in the record that says that the cause was the baby?
No. No. Other than the fact that that's what triggered everything, the whole storyline of how we ended up at the retaliation.
But did any witness testify that she was distressed because her baby had this lead test?
I think it gave her the normal concern of a normal parent whenever they get a bad result, but also the testimony was from the city nurse that Ms. Ludi followed her instructions. Again, she had control over the situation. She followed the directives of her doctors and nurses and the people that were there from the city.
So when we're looking at weighing evidence and looking for competent, credible evidence in the record, it sounds to me, and I don't want to misrepresent, but it sounds to me like there's evidence in the record that suggests, in the form of Ms. Ludi's own testimony and her neighbor and others, that the cause was the landlord.
Yes.
And then there's no evidence, maybe speculation, maybe the idea of it, but no actual evidence to suggest that her distress originated from the lead test with her baby. So how does that landscape affect our appellate review?
Focus on the evidence. The evidence points to the liability of the landlord. And again, it's almost an eggshell theory type of thing. I see that hypothetically, somebody's distressed because their baby has a bad lead test, and then you come over and tell people that she poisoned them, and that she's a bad mother, and puts up abusive signage, and piles on and piles on and piles on because of that situation, I think she takes them as she finds her. Not only that, she takes her as she finds her, and she finds her vulnerabilities and decides to use that as a mechanism to hurt her. Somebody's in a wheelchair, and I shove the wheelchair over. I'm going to then say, well, they had something wrong, they were in a wheelchair? It doesn't work that way. She knew of the situation my client was in and took her as she found her. She didn't help her.
Thank you for your arguments this morning.
Thank you.
We'll take the matter under submission,
Thank you.
issue a timely decision,
Thank you.
and that concludes arguments for this morning.